Hello friends, welcome to Happy Institute YouTube channel. Happy Institute is one among the leading institutes imparting training in stenography. The institute in the last 35 years has helped hundreds of aspirants of government jobs in fulfilling their dreams. Students of this institute have secured top ranks in various All India competitive exams held by UPSC, SSC, DSSB, IBPS, and other recruitment agencies and are working in almost every department of Government of India, be it Ministry of External Affairs, Railway Board, Home Ministry, Election Commission of India, Income Tax Department, CBI, and other prestigious organizations like Supreme Court and High Court. We also publish happy speed dictations for developing speed with passages meticulously selected from latest topics with practical phrases and simpler outlines. This book has become the most prominent choice of almost every reputed institute, teacher, and student of stenography in a short span of time. The proof of its popularity is that in the last 3.5 years, more than 25,000 copies have been sold all over India. We have now launched a series of legal dictations to help aspirants who have to appear in skill test of Punjab and Haryana High Court on 27th February 2022. The dictation is released every day at 1 p.m. on Happy Institute YouTube channel. The students are requested to write and transcribe this dictation and compare with the original passage given in the description more than once if required. Please like and share every dictation that you write and subscribe to Happy Institute YouTube channel. Get ready for dictation, please. 5 seconds. Start. At the outset, the counsel for the petitioner submits that for the time being the petitioner does not press the present petition qua challenge to the FIR as such, and that he has been instructed by the petitioner to restrict the present petition only qua challenge to the warrants issued by the magistrate against the petitioner in the said FIR. Dehors any merits of the case qua the FIR, it is contended by the counsel for the petitioner that the warrants have been issued by the magistrate in a mechanical manner. The application moved by the police seeking issuance of warrants from the magistrate does not reflect any reason for the same. Therefore, the learned magistrate had no reason or occasion to exercise his discretion to decide whether the petitioner was evading his arrest or not. In such a situation, the exercise of discretion by the magistrate stands vitiated, being in negation of law as is laid down by the Honorable Supreme Court in the case of state through Central Bureau of Investigation versus Keskar. Still further, it is contended that since the police had not disclosed any reason even in their application, therefore arrest of the petitioner would be in violation of the provisions of section 41(1) of Criminal Procedure Code. It is further submitted by the counsel that in the absence of any such reasons, the magistrate could not have even authorized the police custody of the petitioner in case of his arrest. Therefore, if the magistrate could not have authorized police custody due to absence of valid reasons, then the magistrate could not have even issued warrant authorizing arrest of the petitioner as such. Notice of motion. Assistant Advocate General Punjab accepts notice on behalf of the state, and Mr. Batra, the senior advocate, accepts notice on behalf of respondent complainant. It is submitted by the counsels for the respondents that the petitioner is involved in a heinous crime of huge fraud. But it is not disputed that the application moved by the investigating officer for obtaining the warrant from the magistrate does not contain any reason, and only this much has been written in the application, that the petitioner is evading arrest. Still further, since the police was not able to arrest the petitioner despite repeated attempts and the raids at the known addresses of the petitioner, therefore the investigating officer had rightly applied for the warrant of arrest against the petitioner. The magistrate is not required to record any reasons for issuing warrants of arrest against an accused. Hence, the magistrate has not committed any illegality in issuing warrants against the petitioner. Before proceeding further, it would be appropriate to have reference to the bare language of the provisions of CRPC, which deals with arrest of a person without warrant, power of the magistrate to authorize the detention of a person after he has been arrested by the police, and also regarding power of the magistrate to issue warrants against a person or accused of a non-bailable offence. If any person acting under warrant of arrest or any police officer having authority to arrest has reason to believe that the person to be arrested has entered into or is within any place, any person residing in or being in charge of such place shall, on demand of such person acting as aforesaid or such police officer, allow him free ingress thereto and afford all reasonable facilities for a search therein. If ingress to such place cannot be obtained under subsection 1, it shall be lawful in any case for a person acting under a warrant or in any case in which a warrant may issue but cannot be obtained without affording the person to be arrested an opportunity of escape for a police officer to enter such place and search therein, and in order to effect an entrance into such place to break open any outer or inner door or window of any house. So, thank you very much इस वीडियो को देखने के लिए। अगर आपको अच्छा लगा हो तो इस वीडियो को लाइक करिए, शेयर करिए, और अगर आप हमारे चैनल पर पहली बार आए हैं सब्सक्राइब करिए। हम और नए नए वीडियोस लेके आने वाले जीके के, जो आपको सारे जनरल नॉलेज के एग्जाम्स में प्रिपेयर करने के लिए आपकी मदद करेंगे। थैंक यू वेरी मच।